Welcome to webinar number 9. What is estate planning and why do I need it? We're really excited to have Morgan Insley from Buist, Byars and Taylor join us. Before I introduce Morgan, just a couple quick housekeeping items. Patrick Gall is also on the call, so he is going to be here for technical support. I know we have a few first-time viewers today, so if you have any problem hearing or you can't see a particular slide, you can just send an email into info@oceansideadvisors.com, and Patrick will be monitoring that email closely to help out if there's any problems. The other item is you should have a Q&A button down at the bottom of the screen, and you could start typing in questions now. You could type in questions throughout the presentation as they come to your mind, and then we will, like we always do on these webinars, we'll try to address as many of those as we can at the end. And yeah, I'm really excited to have Morgan as a special guest. It's the first time I haven't had to put slides together, which I'm pretty excited about. And so as I alluded to a little earlier, so Morgan is an attorney at Buist, Byars and Taylor. She has helped a number of our clients in the past with their estate planning. I really like Morgan's approach to this. Kind of much like the way we operate from a financial planning standpoint. Like, we're not the pushy type, or not the salesy type. And I know in my experience, sometimes I've seen estate planning, it comes across a little salesy, maybe someone trying to sell you a trust that you may or may not need. And so I really appreciate Morgan's patient approach. Sends you a questionnaire. It's really easy, gets to kind of know your situation a little bit better. And the feedback that we've received from clients that have used her services have been really, really nice. So Morgan, thanks for joining us.
Yeah, thank you for the warm introduction and the kind words, Johann. It's always a pleasure working with y'all over at Oceanside.
Yeah, well, yeah, but why don't you go ahead, and I'm sure we've already had a couple questions come in, so thanks so much, Morgan.
Of course. And so, hello everyone. Like Johann said, I'm Morgan. Full name Morgan Michael Insley. I know that middle name's a little bit of a mouthful there. But as he mentioned, today's discussion is going to be centered on what is estate planning and why do I need it. And so I would like to get started just kind of letting you guys know a little bit more about me as a person. And so again, my name is up there. I'm originally from Murrells Inlet, South Carolina. So that's just, just north of here, about an hour and a half, depending on where you're at here in Mount Pleasant. And for my estate planning background, I actually started practicing up in North Carolina. So I am dual licensed. I took the bar in North and South Carolina. So I practiced up in North Carolina for a year and a half or 2 years up there before moving back down to South Carolina. And so I've been practicing here, 3.5, almost 4 years now. And my family, I come from a very large family. I'm the oldest of 5 girls, so all girls in my family. And my husband and I are actually expecting our first child, and it's another girl. So we're very excited to be growing our own family here. And then in terms of, my interests, I really like to paint. I mostly do acrylic painting. I'll do some watercolor. I love to read. And then my husband and I loved going to the movies, at least before COVID. So we're hoping for the day where we can go watch a movie again and get that movie theater popcorn. So, all right. And then I just wanted to kind of give you guys a roadmap for today's discussion. So we're going to talk about, well, what is estate planning? So what makes up an estate plan? What are some of the documents involved? What do they mean? We'll also talk about probate and the probate process. And so what it is, how to avoid it, if you need to avoid it. We'll kind of touch on that from a very high level. And then, of course, we'll go over some healthcare decisions that have been brought about because of COVID, and so how that's kind of changed the estate planning that we're providing. Why you might need an estate plan, or reasons why other clients have had an estate plan done in the past. And then also, we're going to go over some common estate planning myths and how those myths are going to be busted by the time we're done with our presentation. Alrighty. And so in terms of, the big question, what is estate planning? This is the most succinct one sentence, answer I could get for that question. And so on a basic level, estate planning is creating a strategy to handle financial and healthcare decisions during periods of incapacity and to control the use and distribution of your assets during incapacity. And then upon your death, using a variety of vehicles that work together all to form your estate plan. And so we're going to kind of go through now some common estate planning myths, and I included a little cartoon there, especially as we near the holidays, just for a little laugh this morning. And so these are some myths that a lot of people might have a misconception about. The first being, only if you're super wealthy do you need an estate plan. The second one there, estate plans are only for people who think they're going to pass away soon, or I don't need a power of attorney unless I have a medical condition like dementia, or something has come up and now I need to go ahead and get a power of attorney. Oh, I don't need a will, or yeah, if I have a will, then I can avoid probate. And so all of that, those are all myths. And so we're going to kind of go through, and at the end of our discussion today, hopefully those myths are going to be busted. All right. And so in terms of, what makes up an estate plan, every estate plan is a little bit different. No two plans are exactly identical, and there's different documents depending on your particular situation. And so you may have a different set of documents than your neighbor, even if you have somewhat similar situations, so it's very personal. But in terms of, what are the basic documents that might come with a typical simple estate plan, you can see here that's going to be a will, a durable power of attorney, a healthcare power of attorney, and possibly what we call a declaration of a desire for natural death, depending on your situation. We'll talk about those in detail today as well. And then you have a more complicated estate plan, which would include, you still have your will, but maybe we also include a trust. And if you have a trust, then that also includes the certificate of trust, assignment of your property to the trust, beneficiary language, a deed, and then you have the same, powers of attorney there, and possibly that declaration of a desire for natural death. So those are kind of the basic documents that come into play. There may be more, maybe less, just depending on your situation. And so that brings us over to, the dreaded probate process. And so probate essentially is a process that is designed to get property from point A to point B. Point A being when someone passes away, that property that's in their name has to go from their name to the beneficiary, whether that's under their will or under state law. And so that is really the purpose of probate, essentially. And so it's really important to know what assets are, considered probate assets, which are subject to that process, and what assets are actually considered non-probate assets generally. And so they actually pass in a different way. They get from point A to point B in a different method other than going through probate. And so I always like to actually start with the non-probate assets, because those are our special ones. And so if you have a life insurance policy, assuming that you have beneficiaries set up on that, primary contingent, then generally that's not going to go through probate. It goes directly to whoever's named. Same thing with a pay on death, transfer on death account. Whoever's named there to take upon someone's death goes immediately to that person, doesn't bother with probate. Retirement assets, think 401ks, IRAs. Also, you should have beneficiaries set up on those, passing immediately to whoever's named. Any other accounts, so some bank accounts you can have, a beneficiary on, or any other type of property that you can hold that way, will also avoid probate. And then specially titled property with rights of survivorship. So two of the most common would be if you own your house as joint tenants with rights of survivorship, or you can own vehicles, with another person, whether that's your spouse or anyone with rights of survivorship. That's like the key language, and that'll get you, from point A to point B quickly. And so that's not going to be subject to probate. And then we have everything else. And so if you have, over on the left side, you have the real property that's not specially held, personal property, bank accounts, sometimes watercraft, depending on how everything is titled. Then we're looking at the probate process. And so one reason why some clients are eager to avoid probate are the probate fees. And so it's important to note that here in South Carolina, there is no state inheritance tax or state estate tax. And so really, if someone passes away, as long as they are not subject to the federal estate tax, which is currently extremely high, I think it's 11.58 million per person currently. So as long as you don't have, millions and millions of assets, really the only thing you're going to pay is going to be the probate fee, and that is paid to the probate court, and it's based on the gross value of whatever assets are getting from point A to point B in that probate process. And so as you can see on this slide, it's a sliding scale. So depending on how much of your property is subject to probate, that determines what your fee might be. And then here we have just a couple of examples. So you can see, okay, well, let's say your only asset going through probate is a home, and the home's value is $600,000. And we don't take into account any debts like a mortgage or anything. Well, your probate fee is only $845, so it's really not that big of a deal compared to if you have, $2 million of property going through probate. Now we're jumping up to over $4,000. And so that's when you can kind of see, well, as my probate fee gets greater, I'd rather have that money, go and be used for my beneficiaries, or maybe, do some planning to avoid that during my life. And so a question I get all the time is, well, what happens if I don't have a will? What happens with my property? And so if you don't have a will, you're considered to have passed away intestate, meaning without a will. And so there's state law that will kick in and will determine how your property is going to pass. And so it depends on who survives you as to how that happens. So if you have a surviving spouse, but you do not have any children or descendants, your spouse gets everything. If you have a surviving spouse, but you also have at least one child or a descendant, a grandchild or someone in your line who survives you, then actually your spouse only gets half, and then the kids get half, which can be especially problematic if we have minor children involved. It can get really difficult to process that upon someone's death. And so that might be a good reason to have a will. And then beyond that, if you don't have a spouse or descendants, it goes back up to your parents if they're alive. If they're not, then it goes down to your siblings and then their children, like your nieces and nephews, and down the family line that way. And so generally that is under our current law, what would happen if you didn't have a will. But there are a lot of benefits to having a will. And so what is it? The will is a legal document that is going to decide where you can decide who is going to inherit your property, what property specifically each person will inherit, when that's going to happen, and also how that's going to happen. And so I say when and how because especially if you have a minor child or grandchild involved, you may not want them to inherit a bunch of property when they turn 18. We may want to stretch that out, have it be for their benefit so they can use it for, health or education or support, but not allow them to have, $2 million right when they hit 18. Your will also can name a personal representative. And so some states call that an executor. Here in South Carolina, we refer to it as a personal representative. In shorthand, I might call it a PR. And so that person is the one who is going to administer your estate. And so they're going to file all the paperwork with the probate court. They're going to hand them your will if you have one. And it's great to set that up in your will so that you don't have family members trying to decide, well, who's going to do it, which often happens if you don't have a will. So you can go ahead and say, all right, this is the order, and then we avoid fighting, and it makes it simpler and easier, especially for your grieving family members. You can also name a legal guardian for minor children in your will, which is very important if that is applicable to you. And then it's important to note, though, that just having a will doesn't avoid probate. It's actually the opposite. Your will is only going to be able to control the property that goes through probate. And so this slide kind of shows where we're getting from point A to point B. Point A being, the decedent, point B being the beneficiaries. So remember, we have those non-probate assets. They go directly over. If they skip probate, which also means they skip the will. And that's incredibly important, especially if you have, a second marriage, where maybe an old life insurance policy names an ex-spouse. Well, remember, life insurance is special, and so it's going to go straight to that ex-spouse instead of maybe to the new spouse or whoever you would really like to go for that property to pass to. So it's very important to note that the will is only going to cover whatever's in probate. If it's outside of probate, whatever's on that beneficiary designation is going to control. And that brings us to talking about a trust. And so there's many different types of trusts. The one I'm going to talk about today is the revocable living trust. And so this is a way to avoid probate. And it is a legal document separate from your will. And it kind of acts as an extension of yourself during your life. And so it's going to have, your same social security number during your life, and you can retitle assets in the name of your trust. And by doing that, you're going to be able to avoid probate. So the court will only look at what's going into the probate process. If you have a trust, it's kind of like they have blinders on. They can't see what's in the trust for probate purposes. And then upon your death, the trust at that time becomes irrevocable, set in stone, and at that time it gets its own tax ID number. So while you're alive, the trust is a very easy vehicle to use. And it also can control who, what, when, and how your property passes upon your death. So in terms of that, it's similar to the will, but it has a lot of advantages, which we'll go over here in a minute. A trust is also a great tool for incapacity. So let's say that you set up a trust, you retitle assets in the name of your trust, and then you are incapacitated, whether you're in a coma, let's say you have Alzheimer's, whatever that might be. Well, you'll have backup trustees who can continue to manage your property on your behalf, even if you're alive but incapacitated. So it's really great for those situations to already have that set up. And like I mentioned, there's a lot of advantages over a will for using the trust. And so here's a little comparison. So under your will, the assets are going to pass through probate. And like I said, if you have a trust and you fully fund your trust, then the assets are going to pass outside of probate. So you get to avoid probate. That means no probate fee. There's no waiting period because the probate takes at least a year, probably a year to 2 years for even a simple estate, just with all the timing requirements. So it's very beneficial oftentimes to avoid probate. The will is not private. So anyone can go to the courthouse and pull up anyone else's will. It's a matter of public record versus the trust, which is almost always kept private. And so if you have both, the will and the trust, your will is going to say, all right, well, I want all of my property to go to my trust. And that's public record, so people will know you have a trust, but they're not going to know what property you have, who's getting what, who's named to manage it. All that's kept private if you use the trust. So if that's a big concern for you, that's going to be a consideration. Like we just talked about, the lengthy administration of probate is definitely a negative for the will versus a trust. There is no waiting period. You can distribute assets as the trust document determines. And so you don't have to wait a year or 8 months or whatever that is. There's less complexity and ability to plan for complex family situations in a will versus using a trust, especially for, think of a second, third marriage situation or just, complex family dynamics. But of course, the trust is going to be more expensive to set up. And so that is oftentimes a consideration. Is it worth it to really spend the money now to set up the trust versus setting up just a simple will? Yes, there's all these benefits, but is it really worth it to you? And so that's the kind of stuff that we talk about in the consultation. I'll give you my recommendation, but it's always up to you what you prefer. And here's some reasons why some clients might choose a trust. So you can be uncomfortable with your children or grandchildren inheriting a large sum of money, like we kind of talked about earlier. They want to maybe protect the child's inheritance from creditors. And so if you leave your assets to your child in trust, those assets will have certain protections from the child's creditors, the creditors of their spouse, and also in the event of a divorce, those assets would be kept outside of the divorce under current law. The trust also, you can set up who's going to manage the money for children if both parents pass away over a long period of time. And you can set up different levels of that and successors. Obviously, privacy is a big concern for some people. You may want to provide for, a second marriage for your spouse, but also protect some assets to be sure that they do go to children from a prior relationship or to all of your children equally, or however you want to set that up. And then if you have any children with substance abuse issues or special needs, that's always a consideration, and a trust is the best way to protect the assets for that person. So those are just some reasons why some clients may choose a trust. However, with using a trust, the most common mistake we see is, you set up this beautiful trust, but you don't fund it, meaning you don't actually get your property from your individual name to your trust. And so, eventually it'll go there through your will, but it'll have to go through probate. So, all that money you spent in creating the trust is, kind of diminished because you have to then go through probate anyway. So it's very important to retitle assets in the name of your trust and to do that properly. And so we can help you with what types of assets you have and the proper way to retitle those for you. And then you can also name fiduciaries. So that's not only, the personal representative or the trustee, but as this little comic suggests, you also want to name fiduciaries in your powers of attorney. And so in terms of powers of attorney, there's two main types. And so the important thing to note is all powers of attorney are only valid during your life. So you have to be alive for your power of attorney to be effective. Whenever you pass away, that's when the power of attorney switches off, and then the will or the trust, that switches on. And so the durable power of attorney, you're naming an agent to act on your behalf for property and financial matters. The healthcare power of attorney, you're naming a healthcare agent to make medical decisions on your behalf if you cannot make that decision or communicate your own wishes. And so for the durable power of attorney for finances and property, there's two different types of those. They can be immediate or springing. And so if your durable power of attorney is immediate, that means as soon as you sign that document, the person you named as your agent is going to have power over your finances and assets. They are going to be able to see your accounts, manage your property, all on your behalf in your best interest. If it's springing, then that person is not going to have any authority to act for you until a licensed physician has actually declared you to be incapacitated. And so it's very dependent on your situation as to what might work best for you. I will say in general, we tend to recommend immediate because it can be a very fine line, especially as we deal with things like dementia, where you may have good days and bad days. And are you going to get a doctor to really put in writing that someone's incapacitated? Or maybe that person just needs a little bit of help with paying bills or writing a check now and then. And so if you use springing, it kind of dampens your ability to use that to its full potential. And also, I always say, if you don't trust the person you're naming now while you have capacity and can monitor your own property and your own accounts, I don't know why you'd only want to trust them if you lose capacity. That's just, my general sense. There may be a situation that is pertinent to you where the springing might make more sense. So take that with a grain of salt. And then, of course, healthcare power of attorney, that's a wide range of medical decisions. It can be, well, what medication should you be on? It could be, do we have surgery or not? You know, it's a huge wide range. So it's just very important you trust the people you name for those documents. And going right along with that, we have our advanced directives, aka living will. And so this is, you know, end of life treatment decisions. And so in South Carolina, some of those decisions are actually within our state healthcare power of attorney. And so within the power of attorney itself, you're going to make a decision about end of life treatment, you know, pull the plug or not, or let your agent decide. And also the same regarding tube feeding. Would you like to be tube fed or not? Depending on your selections in that document, you may also want to do what's called a declaration of a desire for a natural death. And that's really like the living will, the separate document that is considered to be a living will. And it's pretty much reiterating the same decisions that you make for tube feeding and in different situations, just kind of enforcing your decision regarding that. So those are often, you know, really hard things to come to terms with and really think through, but it's extremely important. And it may be hard to do now, but much better to do it now, get it out of the way, and then if a situation arises, your wishes are known, and it can really make it easier for your loved ones. And so on our next slide here, we also have, well, you know, what about COVID? How has that affected everything? And so COVID has raised a lot of interesting questions in terms of end of life treatment. You know, is a ventilator considered to be a life support, a life sustaining, you know, machine that could be affected by your selection in your healthcare power of attorney? Also, what is your mental state when you're admitted? Some people, when they're admitted, they're fine. They can tell the doctor what they want. Some people progress so quickly, it's too late. And so we need the healthcare agent to step in and say, well, I know this is what she would have wanted or he would have wanted. And so it's more important than ever, at least get those powers of attorney in place now. Don't wait, because if you're waiting until you have something like dementia or Alzheimer's, it's going to be really hard for you to be able to put something in place at that time. And it's better, like I said a minute ago, go ahead and get your decisions out there, let it be known, and then you know you're covered. It's peace of mind. And then also, even if you do, you know, want to pull the plug and that's your decision, we actually have special language that we include now that can handle a COVID situation where, you know, if I'm in the hospital, I'm on a ventilator due to COVID, I would want to be kept alive, you know, with the ventilator in hopes that I survive. But for all other situations, if I'm just being kept alive on life support, go ahead and pull the plug. So we can be very specific and tailor those to whatever your personal decisions are. And then also, as the last point suggests, you know, your primary care physician is going to be a great resource to you. They are the ones on the front lines. They have access to the most recent information. And so if you have questions about, you know, specific healthcare concerns or, you know, COVID related concerns, I would strongly suggest just have a phone call or a meeting with your doctor and go over that. And then if you come up with something that you want to integrate into your document from that discussion, we can do that for you. So that's kind of our discussion of, well, what is estate planning? What are the different documents? And so now we're going to talk about, well, why do I need estate planning? So these are reasons why you may create an estate plan. And so one big reason is really for your loved ones. So they're already going through a lot, whether, you know, something terrible has happened to you and you're incapacitated, or if you have passed away. And so you can make the probate process shorter and easier for them. And you can also control who's going to handle your finances if you're incapacitated. You can make your wishes known regarding your end of life treatment, as hard as a decision as that might be. And also name someone to make medical decisions for you. Because the worst part is having family members fighting over that decision. You know, especially if your spouse can't do that for you and you've got multiple children, it's better to just go ahead and let's get that hammered out now. And then you don't have to worry about kind of the fighting between siblings and kind of keep the family peace. And then also, of course, providing for others upon your death. And so maybe you don't want everything to go to your spouse, or maybe you don't want everything to go 50% spouse, 50% kids. You might want to leave something to charity, or you know, a small bequest to a grandchild, or to a close friend. You may want to have something in there about who's going to take care of your pets. You know, that's in my will. I have one cat, and you know, I'm like, I want this person to take care of my cat, not that one. So, you know, it's the little things like that where you can really kind of get all that in place, and it really gives you a lot of peace of mind. And so that brings us finally to our, you know, estate planning myths. And so remember that first myth, only the super wealthy need estate plans. I think it's clear that that's not the case. Anyone who's over 18 can make an estate plan and probably should. And, you know, 18 may seem a little young for that, but at least for powers of attorney, I mean, think about it. As kids are going off to college, if something awful were to happen to them, you know, God forbid, it would be great for them to go ahead and have that power of attorney in place, especially a healthcare power of attorney naming their parents. That way, you know, everything is in place and they can be protected. Or maybe you're a young family, you know, and you want to name a guardian for your children. Or maybe you are, you know, advanced and you want to name, have some of your property go to your kids, maybe something for grandkids or second, third marriage situations. Whatever your situation is, everyone can benefit from an estate plan. The second one here, estate plans are only for people who think they're going to pass away soon. No. So there's so many benefits to doing an estate plan, even if you're, you know, hopefully nowhere near death. Of course, no one truly knows when that might come. But it's important not to wait till the last minute. You know, estate planning takes some time. You have to really get to know your situation, make recommendations, get everything in place for you. Certain things can be done quickly, but it's really best to just go ahead and get it done while you have time and without any sort of pressing emotional issues going on in your life. The third one there, you know, I don't need a power of attorney unless I start experiencing something like dementia or a medical condition. Again, that is the number one thing that is so hard for me when a client comes to me and they have, you know, advanced dementia or Alzheimer's, because the capacity, for example, to make a will, it's not that great. You just have to know what you own, who your family members are, and how you want your property to go. So that threshold is pretty low. But for powers of attorney, which is almost every single time what the people are like, oh, I need a power of attorney so I can, you know, consent to this medical treatment, or so I can pay this medical bill out of this account. That capacity is extremely high. It's actually the capacity to make a contract. So there's a lot more involved of questions I have to ask to be sure that that person is aware of what they're doing and has that higher level of capacity. And a lot of times, especially if there's been an Alzheimer's diagnosis, it can be really difficult. And I've had to tell clients, I'm sorry, you know, I cannot prepare that for you and allow you to sign it. You know, it's too late at that point. So go ahead and get it done now before we have any sort of issues with that. And of course, finally, if I have a will, I can avoid probate. As we know, it's the complete opposite. The will only governs the probate property. So anything that's not in probate is not governed by the will. And so here at Buist, Byars, and Taylor, we have estate planning services that we provide. And so that's going to include an initial consultation where we discuss your estate planning goals. And so prior to the consultation, as Johann mentioned, we'll send out a questionnaire so we can have some background information, do our own due diligence, and make the most of our time during that consultation. And then after that, of course, we'll prepare estate planning documents on your behalf. We provide a follow-up, you know, to-do list of, all right, well, what are the next steps after I've signed my documents, which often includes the designated beneficiary language. So if you're doing an estate plan, you may need to update the beneficiaries on your life insurance policy or your retirement accounts. And so we provide specific language tailored to your situation if it applies, if we change something that would then affect that asset. If you have a trust, we will provide a revocable trust memo. And so it kind of just talks about, again, what's a trust, how can I use it, how can I fund it, just a little FYI for you. We provide information about creating a tangible personal property memorandum. So that's a special list that you can do here in South Carolina that we discuss in your consultation as an option for you. And so whenever you sign, we also provide another like information packet about that and some examples. And again, you know, I am licensed in South Carolina and North Carolina. Some of our other attorneys are also dual licensed in other states. And so if you have property in multiple states, or if you want an estate plan that's going to be good in both states, we can provide that service to you as well. And that brings us to our questions.
Great job, Morgan. That was wonderful. I'm sure many of the viewers found that helpful. And just a quick question. Can you maybe just go over some of the differences between estate planning and like the probate process between different states? Just some of the common differences. I mean, I'm just looking at our the attendee list and the people that are live on the call. I mean, we have people from North Carolina, Missouri, Minnesota, Illinois, Florida, Ohio. Can you just maybe comment on that? Just some of the basic differences that people should be aware of?
Absolutely. So, I mean, in terms of probate, every state is different, and even every county can be different. So some counties, even within South Carolina, are just, the process and the forms that you do there could be completely different from the ones that you might do in a different county. So it's really specific on where that estate is being probated as to what are the rules, what are the timing requirements. So timing is huge when you're dealing with probate, and so that's, you know, a very big concern. And then in terms of estate planning, there's, I mean, so many differences between states. You know, one big difference I know between South and North Carolina is that, you know, that list that I mentioned, the tangible personal property memorandum. So that's a list of, you know, specific items of your stuff, you know, like furniture, jewelry, sporting equipment, artwork, where you can say, all right, well, my Van Gogh, I want to leave to my sister, you know, Amy or whatever. If you sign and date it here in South Carolina, as long as it meets our statutory requirements, it's actually legally binding. And so it's as good as your will almost, as long as you're able to find it at your death. But in North Carolina, you can have a list, it has no legal effect. And so you're kind of hoping that your personal representative will find your list and go by it, but there's no legal obligation to do so. So it's just little differences like that. Another one I know of between North and South Carolina is North Carolina limits the amount that you can spend for funeral expenses. It's actually a very low amount. I'd have to check the statute to get the exact reference. And South Carolina doesn't have that same limit. So if you wanted a will that's good in both states, you want to be sure that you have some kind of provision that says, you know, if my funeral expenses exceed that amount, I'm okay with that. You know, I want to authorize the payment for that. So it's just little nuances like that. Okay,
perfect. Yeah. All right, and then we have, you must have done a good job because we have a number of pretty like specific questions. So the first one, and this actually came in at the beginning. So question is, I have 2 adult children, son and daughter. My house is paid in full and my son does not want the house. He lives out of state and owns his own home. I have rewritten my will to give my daughter the house. This is her permanent residence. Is there anything else other than the will to make this easy on both kids upon my death?
Yeah, I mean, that's a great question. And so one thing I might bring up to that client is, you know, what's in the will in terms of the house? Is the house given to the daughter? And is there some kind of equalizing payment being made to the son if that's what they want? If that's not what they want, that's fine too. Just something I might bring up. Not everyone wants their estate to be exactly equal, 50-50. But in terms of whether or not there's anything else to do in terms of that house, definitely leave it in the will. Because let's say, for example, that maybe that client were to add daughter onto title by way of a deed during her life. Well, there may be some benefits to that, but one big thing that you're going to lose for estate planning purposes is going to be the step up in basis. And so you want to be sure that, you know, if you inherit property, you get the step up in basis, which we can talk about later, but it's going to be a great tax benefit in terms of capital gains that you're going to potentially lose if you add the daughter to title. So there's a lot of considerations with that. But it's my opinion, not knowing any other facts of the situation other than what you just said, but it's my opinion that having that in the will is the right place in terms of leaving that home to the daughter.
Okay, perfect. Next question is, my mother willed property to me, but I purchased it separately from her 3 years ago. Is this still subject to probate?
So, okay, you're saying your mother willed property to you. I would have to know, was she still alive when you purchased it from her? Um, let's say, for example, that mom's alive. She put in her will that X property goes to you, but before she passed away, you bought it from her. Well, her will means nothing regarding that property because now you bought it from her and you own it. She doesn't own it at her death, so her will no longer applies to that property. But if she had passed away before you bought the property, that would be a different situation. So that's going to be a little more fact specific.
Okay. And certainly the person who wrote that in remained anonymous, but they can certainly reach out to you directly for more clarification. Next question is, my administrator has passed away, so has my attorney. How do I change my administrator without a lot of mess?
So I'm assuming you mean administrator as in your personal representative of the will.
I'm thinking that's what the question is referring to.
And so as long as you're alive, you can always update your will. You can use a codicil if it's something very simple like updating who's going to be your personal representative. But if you have any further changes to the will, especially any changes in who's getting what property, then you might as well just do a new will and just kind of update that. So as long as you're alive and you have capacity, you can update your will. The will isn't set in stone until you pass away.
Great. Next question. What would be time required and range of costs to set up a revocable living trust?
Yeah, so generally time required, it can depend a lot on the client. And so whenever someone reaches out to us, we provide the questionnaire. And so as quickly as you can get that back to me, I need like a day or two to review it normally. If we have a very busy week, it might be the following week before I'm able to schedule your initial appointment. And then after that initial consultation, we'll talk about your different options, what we recommend, and we'll decide on what works best for you. Assuming we get all of our questions answered in that meeting and we know exactly what we'll be doing, we provide an engagement letter. And so as soon as you sign that and return it to me, it officially hires us as your attorneys to do the work for you. So whenever I get that letter, it takes 2 to 3 weeks, probably closer to 3 weeks right now, for us to get drafts to you. And then we'll have a follow-up meeting or phone call to go over the drafts. And then after everything is good, we'll sign. So some clients, they want to take their time and really review those drafts in detail. So it might be a month later before we meet to discuss. Other clients are ready to get going, and so they're, right on there. So I'd say like a month to 2 months would be a fairly quick process, but it could take longer. It just depends on the situation and the client. And it's really the same regardless of whether you have a trust or a will. So our turnaround time isn't affected so much by that. And then the cost range is going to be very specific to everyone's situation because no two trusts are the same. A very simple trust is going to be different in terms of the time and the cost versus a trust that has a lot of complex family issues or a lot of complex drafting, a lot of specific gifts to different people. And so that's why, we provide your cost to you in the engagement letter so that you know exactly, kind of either a range or the exact fee that it's going to cost you. And we can even talk about that after the meeting, the initial consultation. All right, well, if you go with option A, which is just the will, it's going to be about this much. If you go with option B, which is the trust, it's going to be about this much, and then you can decide.
Okay. Well, good, Morgan. I know you're a very busy lady, so we sincerely appreciate you taking the time to share your expertise and help educate our viewers here. And estate planning is such an important part of the whole financial planning process. And it was actually a client of ours who came up with the idea. He said, I love your webinars. Do you mind doing one on estate planning? And I thought about it. I was like, I could probably put together a decent estate planning presentation, but why not have a true expert that does this every day come in? So we really appreciate you taking the time to do this. And certainly if anyone's interested in contacting Morgan, feel free to reach out to her directly, or if you would feel more comfortable reaching out to us first, and we can introduce you, we'd be happy to do that. Certainly, if you do end up working with her, we would love to have those wills and trusts, those final documents with us, so we have a copy of those. And yeah, we as always, we appreciate everyone taking the time to watch the webinar. And yeah, I think everyone's going to really enjoy this, Morgan. So I'll let you know the feedback.
Awesome. Well, thanks so much for including me. Always a pleasure working with you guys.
Yep, that sounds good. Everyone have a nice day, and we'll talk to you soon. Thanks.